Swati Sharma, Executive Officer, Shayna Avila, Staff Engineer, Lauren Chandler, Ombuds, Alicia Delphin, Administrative Liaison, Greg Forrest, Board Counsel, Rana G. Joshi, Environmental Scientist, Linda Ocampo, Senior Staff Engineer, Firdos Permirza, Environmental Program Manager, and Marcus Raymond, the Senior Environmental Scientist. This meeting is being live streamed and recorded. Your continued participation is acknowledgement that you are being recorded. Today is April 27, 2026 at 11:30 a.m. and the meeting is now called to order.
Thank you very much, Sheena. Please call the roll.
Thank you, Chair Rakestraw. And for the record, Board Member Ingrid Brostrom is recused for agenda item number 3, the initial order on appeal for the Fibrotech facility, and will be joining us tomorrow for day 2 of our meeting. Member Atkins.
Here.
Member Williams.
Here.
Vice Chair Strauss-Hacker.
Here.
Chair Rakestraw.
Here.
4 members are present and a quorum is established. I will now review some logistical items. Today's hybrid meeting is being held both in person and remotely via phone and Zoom. For those joining us on Zoom, please select either English or Spanish as your preferred language option by clicking the interpretation icon located at the bottom of your Zoom toolbar. If you don't see the icon, you may need to update your Zoom application. If anyone experiences connectivity issues with Zoom, you can call in for either English or Spanish. The phone numbers are provided to you now on the slide. They will be provided in the Zoom chat, and they are also posted on our website. Agenda item times may fluctuate to accommodate agenda items. Meeting materials are available on the registration table at the entrance of the chambers. They can also be found on our website at bes.dtsc.ca.gov/next-meeting. To protect everyone's virtual space and networks, the Q&A function will serve as our chat feature. It will be used for individuals that are experiencing technical difficulties or are unable to make verbal comments. If you wish to have your written Q&A comment read out aloud during a public comment session, please begin your comment with "Please read aloud." To ensure that all board members are fully present and focused on today's presentations and discussions, they are not reading or following along in the chat or Q&A. All participants will remain muted until a Zoom host unmutes them once recognized, and only the presenters' videos or screens will be shared. We are looking forward to hearing from the public throughout the meeting and have scheduled times on the agenda to do so. There are several different ways in which you can participate. For those joining us on Zoom, please raise your virtual hand on your Zoom toolbar or press *9 on your phone. I will call on participants using their name as displayed on Zoom, and I apologize in advance if I mispronounce any names. If you have joined the Spanish channel, please wait for the interpreters to provide instructions. To ensure our board members are able to hear comments from all members of the public who wish to comment today, we ask that you take no longer than 3 minutes to make a comment. For those commenting in Spanish, time will be doubled to allow for translation. Agenda item number 3, the initial order on appeal for the Fibrotech facility, is the first agenda item this morning following the board chair's opening remarks. We will be utilizing a number system to facilitate our in-person public comments for the initial order. So at this time, I would like to take a poll for those in the room, specifically for agenda item number 3 for the Fibrotech initial order. Please raise your hands if you plan to comment this morning. Okay, and if you have not received a number, our staff will provide you with one prior to us taking that public comment segment, because that is the order that I will call for in-public comments. And for Zoom, for those participating on Zoom, if you plan to comment during today's initial order for the Fibrotech facility, please raise your virtual hands now. Seeing one hand raised on Zoom only. Thank you, Jesse Flores. Okay, so our public forum for items not on the agenda will be heard tomorrow, April 28th, as agenda item number 6, which will be held at approximately 12:25 p.m. If you would like to express your comment in writing, you may submit your comment via email to besinfo@bes.dtsc.ca.gov. at bes.dtsc.ca.gov. That concludes the introductory remarks for today's meeting. I will now hand it over to Chair Rakestraw for agenda item number 2.
Good morning, and welcome to today's Board of Environmental Safety meeting. The Board of Environmental Safety is a 5-member board created by Senate Bill 158 in 2021, which enacted fiscal and regulatory reforms to the Department of Toxic Substances Control to improve the transparency, accountability, and fiscal stability. The board members represent the general public interest and act to protect public health and reduce risks of toxic exposure with a particular focus on disproportionately burdened and vulnerable communities. We appreciate your participation today as we work collectively to achieving the goals and objectives set forth in SB 158. As you may have noticed, we have 2 new board members on the dais that I would like to introduce. Senator Tony Atkins was appointed by the Senate Rules Committee in February and brings many years of extraordinary public service to the board, including as a member of the San Diego City Council and the first person in 150 years to serve as both Speaker of the California Assembly and Senate President pro tempore. Welcome, Senator Atkins. In January, the governor appointed Reese Williams to the board, who joined the board at the start of this month. Mr. Williams has served in Governor Newsom's administration as Chief Deputy Cabinet Secretary, Senior Advisor on Emergency Preparedness, and Acting Deputy Chief of Staff for Infrastructure. Welcome, Member Williams. I'm very excited by these appointments and look forward to working closely with both of you. And each of you will have the chance to more fully introduce yourself during the board member reports later today. I'd also like to take the time to introduce the board's newest environmental scientist, Ranaji Joshi. Welcome, Ranaji. And so now turning to today's agenda, which is composed of 2 main items. So first today, the board will consider the initial order for the FiberTech facility permit appeal. After that concludes, our Executive Officer, Swati Sharma, will provide us with her Executive Officer report, which will also include board member reports. And we're scheduled to end today by 4 p.m. So that concludes the introductory remarks. We'll right into agenda item number 3. So in 2021, SB 158 provided this board with the authority to hear and decide appeals of DTSC's hazardous waste facility permit decisions. Prior to SB 158, permit appeals were heard by a permit appeals officer located within DTSC. This board has spent significant time finalizing its regulations and standing orders for the administration of its appeals and has heard 2 appeals to date, which were completed following the appeals rulemaking in 5 and 8 months, respectively. The board's role in hearing and deciding permit appeals is critically important. One of my priorities as board chair is to ensure that these permit appeals are fair, transparent, and timely in order to increase trust in DTSC's permitting system. I do want to emphasize that the initial order for the FiberTech permit, the issue being considered today, is just that, an initial order. The substantive issues will be briefed between now and the hearing date in late October. So I'll now hand it over to Linda Ocampo, our senior staff engineer, and our board counsel, Greg Forrest, to present the initial order, or the draft initial order for the FiberTech permit appeal. So Linda, over to you.
Okay, thank you, Chair Rakestraw. And I'll get started with the board staff presentation for the FiberTech permit appeal. All right, I'll begin with a brief background on the appeal, then walk through the elements of the initial order, including its purpose and the issues screened for review. Then I'll hand it off to the board's legal counsel, Greg Forrest, to cover the effect of the stay, the briefing schedule, and the public hearing date. And just a reminder that we did include a copy of the draft initial order and the summary of issues in the meeting packet for anyone that wants to follow. All right, and for those who might be less familiar with this case, FiberTech, or PTI for short, is a chemical manufacturing facility in Santa Fe Springs. It treats and recycles metals from inorganic hazardous waste, such as copper-bearing etchants, and produces copper and iron-based products for the electronics, semiconductor, and water treatment industries. The facility has operated under the conditions of the 1991 permit and subsequent permit modifications. Then on February of 2025, DTC issued a decision granting PTI a renewal operating permit. That decision was appealed by Neighbors Against Fibertech, or NAPT for short, and the facility itself. The filing of these appeals automatically stayed or paused the effect of the 2025 permit decision. Okay, this graphic shows the major milestones in the permit appeal to date. After DTSC issued the permit in February of 2025, both appellants filed their appeal notifications and petitions within the timeline set in statute. The administrative record process extended from March of 2025 through April of 2026. And I'll cover some of those challenges in the next slide. We are now at the initial order stage where the board takes action to set the next steps, those being the filing of briefs by the appeal parties and the final hearing slated for October later this year. The board's decision at the hearing will be recorded in a final order that will be issued within 30 days from the hearing date. So I want to briefly address the administrative record as it affected the overall appeal timeline. DTSC is required to compile and complete an organized record under the board standing order. Given more than 30+ years of material in mixed and older formats, organizing and compiling in accessible formats for all parties took longer than expected. Both appellants and board staff raised concerns about the volume, the organization, and the difficulty of navigating the record. Some of these concerns were addressed by digitizing more records and bait stamping the files. Then earlier this month, after a ruling on motions from the board chair and vice chair, DTSC completed the record, and it is now ready for the briefing stage. All right, now that we cover the work leading up to this point, we'll get into the initial order. The initial order establishes 4 procedural elements: the acceptance or dismissal of petitions, the effect of the stay, the briefing schedule, and public hearing date. Each of these elements are addressed in the initial order before the board today. To determine whether to accept or dismiss a petition, we first screen the issues in the appellant's petitions. The screening criteria are set in statute. Issues are accepted for review if matters are within scope of the appeal regulations and statute, and either were previously raised in comments or testimony during public review of the draft permit, or first appear in the final permit. I'd like to note that the acceptance for review is not a decision on the merits. It simply means that the issue will move forward for evaluation at the hearing. With that framework in mind, we'll now look at the issues raised by the appellants and the screening results. And we'll begin with the issues raised by NAPT, Neighbors Against Fibertech. Okay, Neighbors Against Fibertech in its petition raised 5 issues. All met the screening criteria with one on a partial basis. The first issue raised concerns whether DTSC based its permit decision on a complete administrative record. Concerns around the administrative record for the draft permit were previously raised during comment period, and deficiencies with the administrative record for the final permit arose for the first time with issuance of the final permit. Therefore, this issue meets the criteria for review. The second issue challenges whether DTSC conducted a complete compliance history review. This issue was previously raised during public comment. The third issue concerns whether DTSC should have denied the permit based on the facility's history of compliance. This issue was previously raised during public comment. The fourth issue concerns whether DTSC failed to evaluate cumulative impacts and community vulnerability before issuing the permit. NAPT raises this issue under 2 claims. First, that DTSC committed a procedural error, and second, that DTSC abused its discretion. This issue is partially accepted, and I'll walk through the regulatory context and the screening of this issue in the next 2 slides. Lastly, issue 5 focuses on whether DTSC abused its discretion by relying upon the health risk assessment provided by the facility. This issue was previously raised during public comment. To understand the procedural error claim raised under issue number 4, it's helpful to go over the regulatory context. SB 673 required DTSC by January 1st of 2018 to adopt regulations for criteria to strengthen the permitting program and increase community protections. DTSC implemented this criteria in 2 tracks. Track 1 includes the violation scoring procedure, personal training, health risk assessments, financial assurance, and financial responsibility. These took effect in 2019. Track 2 criteria includes community vulnerability and setback distances, but have not been adopted and remain in the rulemaking process. This context is important as NAPT's procedural error claim relies on Track 2 standards that were not in effect when DTSC issued this permit. Right, returning to the screen of issue 4, NAPT argues both that DTSC committed a procedural error and that it abused its discretion in its treatment of cumulative impacts. The treatment of cumulative impacts was raised during the comment period for the draft permit. DTSC explained in its response to comments that while community vulnerability criteria were not yet in effect, the existing regulations allow DTSC the discretion to consider cumulative impacts and did so using CalEnviroScreen. Based on the record, staff recommendation is to accept the abuse of discretion claim, which allows for the evaluation of whether DTSC's approach using the discretionary tools available at the time was reasonable, and dismiss the procedural error claim as it's based on standards that were not in effect at the time of the permit decision. All right. Next, we turn to the petition submitted by PTI. PTI raised 5 issues that met the screening criteria. Issue 1 focuses on whether DTSC made an error by setting the permit term at 5 years. This issue was previously raised during the comment period. Issue 2 concerns whether DTSC made an error by imposing a 3-year tank certification interval under permit conditions 47C instead of the 5-year schedule and regulation. This issue was previously raised during the comment period for the draft permit. Issue 3 concerns whether DTSC made an error by imposing requirements for volatile organic compounds and permit conditions 65 through 67. Concerns about the applicability of requirements were previously raised during the comment period. Issue 4 concerns whether DTSC made an error or abused its discretion by imposing permit condition 71, which requires development of a community air monitoring plan and installation of off-site monitoring equipment. Permit condition 71 appeared for the first time in the final permit. Issue 5 relates to whether DTSC made an error and abused its discretion by imposing permit condition 74, addressing surface water runoff. Condition 74 appeared for the first time in the final permit. After our review of the issues raised in both petitions, along with DTSC's response to comments, and the final permit, board staff recommends accepting both petitions in full, with the exception that NAPT's issue 4 is accepted on the abuse of discretion basis. This determination sets the scope for briefing and the matters that will come before the board at the public hearing in October. With the scope of issues now established, I will now turn it over to our legal counsel, Greg Forrest, to walk us through the effect of the stay, the briefing schedule, and the hearing date. Thank you.
Thank you, Linda. As Linda mentioned, one of the purposes of the initial order is to determine the effect of the stay, and that is what I am covering next. If I can get there. Oh. First, I want to explain what a stay is and how it works. A stay is a procedural pause on the effect of a permitting decision. It keeps the permit from taking effect so the decision can be reviewed. The stay is automatically continued if an appeal is filed. Based on an analysis that I will cover, the board determines the effect of the stay when it adopts the initial order. Once the stay is lifted, the permit takes effect. If the board were to dismiss the appeals in their entirety, the stay would be lifted at that point. As you have seen, we are recommending that the board accept the issues presented for these appeals. A bit of history here. The automatic stay has been a feature of the permit appeal process since its inception. As you know, the board took over permit appeals from DTSC's permit appeals officer 4 years ago. Historically, appeals were limited to conditions, but the board changed that by expanding the scope of permit appeals to include contested issues. That means the board must decide how to characterize the issues. The effect of the stay is limited to the issues that are accepted for review. That is reflected in the initial order, where the board determines what parts of the permit will remain stayed based on the issues that are accepted. If no issues are accepted, the appeal is dismissed and the stay is lifted. If conditions are contested, the board determines whether any other conditions are intertwined with those contested conditions, and the board extends the stay to include the conditions that are contested along with the others that cannot be severed. Because of the complexity around the stay determination and the relationship to the issues, conditions that cannot be severed, the board invited the parties and DTSC to submit briefs on this topic. In the first round of briefing last summer, the board asked the parties to tell us what parts of the permit should be stayed, assuming the board accepts all of the issues that are raised in the petitions. More recently, in March of this year, the board requested a second round of briefing. We asked the parties in DTSC to explain all contested and uncontested conditions tied to each appeal issue, including how each condition relates to the issues raised by PTI and NAPT in their petitions. We also asked them to justify maintaining the stay and to identify the harm that would result if uncontested conditions are not stayed. Next, I am going to go over the analysis that we received from the parties in response to our request for briefing. NAPT proposed a full stay. This would have the effect of continuing the existing stay of the 2025 permit decision for the entire appeal process. The stay would only be lifted if the appeal is dismissed or denied. In support of that proposal, NAPT argued that their appeal was fundamental because it challenged the permit decision itself and was not limited to individual conditions. They argued that a full stay was needed to preserve the status quo while the appeal is heard. They argued that allowing new conditions to take effect would undermine the appeal. The implications of this proposal would mean that the facility would continue operating under its modified 1991 permit. Any operational changes allowed by the new permit would remain stayed during the appeal. In response to the board's request for briefing, FiberTech proposed limiting the effect of the stay to only the 6 conditions that they challenged in their petition. They considered all other conditions to be severable. This would mean that the permit would take effect now, and the stay would only continue to apply to the 6 conditions that they contested. They argued that the board's regulations require a narrow issue-specific analysis tied to permit conditions. They also argued that the public interest favors allowing the 2025 permit to take effect because it provides greater community protections and oversight. The implications of this proposal mean that the facility's operations would change to match new permit terms and conditions because the permit authorizes physical changes to the facility. It would also mean that DTSC's regulation and oversight of the facility would occur separately from the board's appeal process. In response to the board's first request for briefing, DTSC responded that if the board accepted all issues raised in the petitions, then a full stay was warranted. In response to the board's second request for briefing, DTSC took a neutral position, deferring to the board's decision on the stay. Because DTSC did not offer any analysis of how the conditions in the permit relate to issues in the petitions, the board's decision will turn solely on its own regulatory interpretation and arguments offered by the parties. The staff recommendation for this item is a full stay. Our recommendation is described in the draft initial order that was sent out last week. And it's based on our own legal research of the applicable law, our review of the appellant briefs, our analysis of the renewal permit conditions, and our interpretation of the stay regulations. In particular, we focused on the specific outcomes sought by the parties in the current appeal. We concluded that a full stay avoids operational changes that could conflict with an appeal outcome. A full stay ensures the availability of meaningful relief if the permit is ultimately set aside and remanded following the board's decision on the merits at the public hearing. I will be available later in the meeting if you have any questions on this. The initial order also establishes a briefing schedule. Opening briefs are due 60 days from issuance of the initial order. Opposition briefs due 45 days after opening briefs, and then reply briefs due 15 days after opposition briefs. The appeals will be heard jointly at a public hearing tentatively set for October 21st and 22nd of this year at a location and time to be determined, but will be in the Los Angeles area. We maintain a running docket for the appeals on our website where we post briefs, correspondence, and other information regarding the appeals. Our website address and email are listed on the slide. I want to give special thanks here to Linda Ocampo, Sheena Brooks, and the other members of our board staff who put the work in to get us to this point. That concludes my presentation.
Thank you very much, Greg, and thank you, Linda, for the presentation. If it's okay with our fellow board members, I think we'll allow for questions and answers of Linda and Greg after we hear from public comment and after we hear from the appellants as well. So at this time, we'll now hear from the appellants in this matter. So I'd like to first start by calling on Earth Justice's Council or Neighbors Against Council, Byron Chan, who is representing the petitioner Neighbors Against Fibertech. Please join us at the podium, and you have 5 minutes for remarks. Thank you so much.
Good afternoon, Chair Rakestraw and members of the board. My name is Byron Chan on behalf of Neighbors Against Fibertech. Neighbors Against Fibertech is a community organization dedicated to protecting the health of residents in Los Nietos, Santa Fe Springs, and nearby communities from the environmental harms posed by Fibertech's hazardous waste operations. For decades, Neighbors Against Fibertech has worked to hold DTSC and Fibertech accountable for Fibertech's long history of violations and mismanagement. Neighbors Against Fibertech respectfully urges the board to adopt the proposed initial order. The order appropriately recognizes that the issues that Neighbors Against Fibertech raises in its petition meet the requirements to challenge permitting's decision to grant the renewal permit and therefore are properly before the board. Neighbors Against Fibertech also urges the board to adopt the proposed stay of the entire renewal permit during the appeal. A complete stay is appropriate because the issues raised in the petition challenge permitting's decision to grant the renewal permit itself. The board's appeal regulations do not allow the board to let portions of a potentially invalid permit to take effect before the board has determined whether that permit was lawfully granted. To the extent that there are arguments that the stay should be narrowed because the renewal permit is supposedly more protective than the existing permit, those arguments should be rejected. First, that claim of protectiveness is unproven. And second, protectiveness is not the legal test for the scope of the stay. The scope of the stay turns on the issues that the board accepts for review. And because the issues that Neighbors Against Fibertech raises challenge permitting's decision to grant the renewal permit, the board's appeal regulations demand staying the entire permit. Neighbors Against Fibertech does request one modest adjustment to the proposed briefing schedule. The current schedule provides 15 days for reply briefs. We respectfully request 30 days for reply briefs instead. And under that schedule, briefing would be complete by September 9th, which would still give the board ample time to review the briefs before the October 21st public hearing. So in short, we ask the board to do three things. First, adopt the draft initial order. 2, maintain the stay of the entire renewal permit. And 3, extend the reply brief deadline from 15 days to 30 days. Thank you for your time and consideration.
Thank you very much, Council. So I will now call on counsel representing the FiberTech facility, Zach Walton of the SSL law firm, to please join us at the podium. You will similarly have 5 minutes for remarks. Thank you.
Thank you, Zach Walton on behalf of FiberTech. At line 17, or I'm sorry, at page 17, line 11, the order says that the board requested but did not receive analysis showing how the board's resolution of the issues presented in the appeal could be reconciled with a limited stay. And respectfully, we did not understand this to be one of the questions we were asked to address in the supplemental briefing. This question is based on the California Supreme Court's decision in the Varian case. The court ruled in Varian that a trial about defamation had to be stayed while the Court of Appeals considered whether the lawsuit itself infringed on the defendant's right to free speech. We don't think that this case technically applies, and we can get into that if it would be helpful. But I think that the fundamental question that is being asked is whether there's an inherent conflict between lifting portions of the stay and an appeal that challenges the permit decision. And the first thing I would say about that is that the regulation expressly contemplates narrowing a stay of a renewal permit for an existing facility while on appeal. Now, going back to this Varian question, at page 16, line 7 of the order, it says that the briefs you received did not consider how the conditions in the renewal permit are related to the issues raised in appeal. We believe our supplemental brief addresses this at the bottom of page 11 through the middle of page 14. But in light of the direction of the order, we ask that you consider this issue with regard to 2 narrow issues. Now, Neighbors challenges the permit decision for 5 reasons, but of its claims, the one that directly relates to the operation of the facility concerns cumulative impacts and community vulnerability. Neighbors contends that the renewal permit allows FiberTech to expand and that this will impact the community, and that the department failed to properly evaluate the vulnerability of the community in light of this. We'd like to address this in 2 specific cases involving the receiving area and tank F2A. Now, the renewal permit requires FiberTech to reconstruct the area where waste is first received. The waste is put in an asphalt receiving area, and it is sampled to confirm that the facility can accept it for treatment. And assuming that we can, it is then transferred to a storage area with secondary containment. The receiving area is just asphalt. It's not lined. Under the new permit, the asphalt will be replaced with concrete secondary containment. This ensures that if a container leaks, it will not impact the environment. This is a compliance issue. It's not an expansion, and it does not contribute to the community's vulnerability. Tank F2A treats ferrous material, and the solids from the treatment of that material are transferred to a 3-foot-high open copper pan that's called the dry basin. And it is only covered with a tarp. And the department would never permit it today. The new permit replaces the old tank and the dry basin with one self-contained tank. This is a real improvement. It is not an expansion. It does not impact the community. It is a compliance issue. Now, the new permit also allows FiberTech to install 2 new wastewater treatment tanks, and this will increase the capacity to treat wastewater, but it is substantially less than the amount we are currently permitted to treat. We don't believe this will cause impacts, but it is a change in operations. So this is different from the receiving area in tank F2A. I believe you are being asked whether neighbors will be prejudiced if you allow uncontested conditions of the permit to take effect. They won't be if the receiving area has secondary containment or tank F2A is replaced with a self-contained tank. This takes us to the variant issue and whether you can reconcile a limited stay with a challenge to the permit. If you let these 2 conditions take effect and then rule against us on the merits, the reconstructed receiving area will no longer be authorized to store waste, and the replacement for tank F2A will no longer be authorized to treat waste. That is consistent with the relief that Neighbors wants. And if Neighbors is successful in this appeal and the facility must close, then it will close pursuant to a department-approved closure plan. If we reconstructed the receiving area and replaced tank F2A, we will have to remove them pursuant to the plan. Neighbors will get the full relief that it seeks. We think that is how you resolve the question you are being asked to answer. And that is why we ask you to reconsider the order with regard to these 2 items, the receiving area and tank F2A. And our plant manager, Dave Clark, is here to answer any questions you may have. And I'll say also that we don't object to the adjustment to the stipulation, to the briefing schedule that Byron mentioned. And we look forward to having the hearing in October. Thank you.
Thank you very much. So now we will turn to DTSC. I'd like to invite Permitting Division Chief Wayne Lawrenson, who is representing DTSC, up to the podium. Nice to see you, Wayne.
Nice to see you too. Good afternoon, Chair Rakestraw, members of the board, new members of the board. My name is Wayne Lawrenson. I manage the permitting division at DTSC. And I don't have an ask on the order today. I think we respect the board's role and decision-making authority on all of the items in the initial order, and we defer to the board. But how I want to use my 5 minutes is to talk a little bit about our permits, because our permits are often misunderstood in the public's eye and in other venues. A permit is often thought of as a thumbs up or a thumbs down. Do we get to operate? Yes, you do. Do you get to operate? No, you don't. That's permit denial. Our permits are meant to protect communities, and we spend a lot of time and thought reviewing permit applications and the ways that equipment are proposed to operate to create protective permit conditions that may be very technical. If you look at the FiberTech permit, there are a lot of technical permit conditions that may not make sense to the average person that's not familiar with the facility. But there are special conditions in the permit that do make a lot of sense for the communities especially. And so I wanted to talk a little bit about that. When we put together permits, we primarily put together restrictions on operations. That's what our permits consist of. In fact, the FiberTech permit is 193 pages of permit conditions. Those are broken down into unit-specific conditions. So there's different types of hazardous waste management units at the site. A tank has a bunch of conditions. A storage area has a bunch of other conditions. And then we have what we call special conditions. The special conditions apply to the entire facility. And in this case, consist of things that are very beneficial and protective for the community. Other things that we put into permit conditions, we establish procedures that must be followed. So if a facility comes to us with a plan on how they're going to operate, we don't just accept it. A lot of times we'll put prescriptive procedures for how that unit must operate in a permit. Another thing that we do is we look at compliance issues and establish requirements to improve. So we look at that long compliance history and we identify areas that the facility may have issues with complying with. And then we try to bolden up that permit with conditions that not only help the facility comply, but help inspectors understand what they're looking for when they come out. And then the last thing that we do, and this comes during the last stage of our permit process, is understanding the community perspective. We spend a lot of time talking to people like Jaime and Neighbors Against Fibertech and understanding the community perspective about neighbors that live around the facility so that we can craft permit conditions that protect people that live in the area that have a perspective that we do not have sitting in Sacramento writing a permit. And a couple things about the Fibertech permit. This is not a permit for the entire facility to operate. It's a permit to authorize treatment and storage operations at the facility. 193 pages of permit conditions. It includes prescriptive processes for management of hazardous waste, conditions based on many years of review. This is our longest continued permit in the history of DTSC. It includes compliance history and input from community and stakeholders. And it includes some very beneficial components that include there's a community health and safety plan element in there which establishes the role for Fibertech to work with the community to establish a community health and safety plan that they can use to understand what happens if there's an incident at the facility. Another condition is community air monitoring, which you may know is a subject of the appeal, verifying waste streams, and then also an annual community meeting where Fibertech explains the past year's environmental monitoring results to the community so that they have a good understanding in plain language about what the results of that community air monitoring has been. So with that, I want to end with a close, just simply that this permit, the permit that you have before you, is protective of the Los Nietos community and the environment. And I believe everyone here today wants that protection, but I understand that we have different perspectives of about how that is best done and about the permit that we finalized to solidify those protections. As we assemble our briefs, share our different perspectives, and defend each of our positions, we have a great deal of respect for those different viewpoints and the board's process for deciding the outcome. Thank you very much.
Thank you very much, Division Chief Lawrenson. So thank you to all the parties. So next we will open the floor to receive public comments on this item. I want to remind everyone that we are only considering the initial order here today, and know that we will be holding a full public hearing on this appeal in October. So Sheena, I'll turn it over to you to open the floor for public comments.
Thank you, Chair Rickstraw. So the floor is open now for agenda item number 3, initial order on appeal for the Fibertech facility. Again, we have public comments for 3 minutes per commenter. And for all public commenters, if you would like to be identified for the record, please state your name and affiliation. So for those in person, if you can please raise your hand if you would like to comment but have not yet received a number, and Alicia will give you a number. So while Alicia's passing out those numbers, will the first 4 please come up? I believe that's numbers 20 through 24. Please come up for the podium. Whoever has numbers 20 through 24, please make your way up to the podium now. Whoever has numbers 20 through 24, please make your way to the podium now. So numbers 20 through 24, we'll hear 20 through 24 first. You may go ahead.
Before we begin, I would like to respectfully request 1 additional minute from the board for my public comment.
Thank you. That's okay. Yeah, you can have 1 additional minute. Thanks.
Good morning, board. My name is Jaime Sanchez. I am a resident of Los Nietos and a member of Neighbors Against Fibertech. It is important that you understand that we have been impacted historically by Fibertech, a serial violator of the law. In conjunction with DTSC's, whose malfeasance has not only resulted in its failure to fulfill its mandate to protect the public, communities, and the environment, but is also engaged in conduct which conversely benefits the toxic substances industry. I ask you here and now, what is DTSC's threshold for denial or revocation of a permit? The answer is there is none. Consider Exide, Fibertech, and Ecobat. Consider DTSC's claim that it lacked sufficient evidence to deny or revoke these permits while failing to apply existing criteria and ignoring the facts. In fact, in each case, the evidence supporting revocation or permit denial is overwhelming. Pursuant to Health and Safety Code Section 25186, all of the prima facie elements supporting Fibertech's permit denial have been satisfied. DTSC's permit renewal also allows Fibertech to expand the facility with new construction. The rhetoric used by DTSC to justify the proposed expansion relates to language in the original permit concerning production capacity. It is obvious that the intent of the original permit was based on the existing infrastructure at the facility and made no mention of future expansion in order to maximize capacity. Once again, DTSC is distorting the facts in order to benefit the toxic substances industry. By analogy, it is the equivalent of DTSC granting Fibertech in 1991 permission to fly to the moon, utilizing the existing facility. That decision does not, in 2025, allow DTSC to grant Fibertech permission to build the Kennedy Space Center. DTSC's rationale is contrary to a reasonable interpretation of the facts and without merit. It is the equivalent of DTSC attempting to justify the tail wagging the dog, not the tail wagging its tail. I'm sorry, not the dog wagging its tail. We comprehend the ramifications of your decision here today. The implications are clear and unambiguous. So we ask you to place yourselves in our shoes and contemplate the consequences of your decision. We remind you that BES was created by the legislature with the intent of prioritizing protection of the public, communities, and the environment, because DTSC had and has failed to do so. We ask you to consider the following. Will BES become the avatar of DTSC, or will it remain independent and fulfill its mandate? In conclusion, we urge BES to grant the appeal by Neighbors Against Fibertech in its entirety, and that the entire renewal period be stayed pending the proceedings. Thank you.
Can I go now? Oh, one sec. I gotta go. Okay, awesome. Hi, my name is Jesse Flores, Executive Director of local nonprofit Norwalk Unidas. Since February of 2024, Norwalk Unidas has been partnering with Neighbors Against Fibertech to really uplift the concerns that residents have had, who live near Fibertech, surrounding just really the long history of violations in the neighborhood. So really, these violations have been well documented, as described in the 2023 Cal Matters article. These violations include uh, leaking containers, crack containment barriers, and poorly maintained wells, cancer-causing chemicals, trialchloroethylene, and hexavalent chromium were found in the soil and groundwater under and near the PTI plant, and equipment has released ammonia gas, which can burn lungs if inhaled. And so really, as a really grassroots organization, we not only took it upon just reading this article to see, okay, how do we continue to push for and uplift residents' concerns, but we also took it upon ourselves to try and measure some of these really just just air pollution and everything around the facility. And so most recently in October, we did some preliminary air monitoring, but as very small organizations, right, we couldn't really do such comprehensive measurements of the various just dangerous contaminants that could be in the air. And so we really just did particulate matter, but I think it really just gave us this good exercise as to how do we try and identify the different hazards. And so we look forward to continuing to see ways as to how we can uplift some of these hazards and see how we can then communicate it to you all. And so, yeah, thank you.
Good morning. My name is Jenny Knack, and I'm here with Parents Against the Santa Susana Field Lab. Oh, yeah, thanks. This isn't my site. This isn't my neighborhood. But I just want to say how concerned I am that Chairperson Brostrom has recused herself, because it's my understanding that she had not actually represented Neighbors Against Fibrotech. And in the years leading up to the creation of this board, it was our desire that we would be eventually represented by people who had an environmental justice perspective. And I'm concerned that the board's changing of its, not only board members, but the removal of someone whose perspective would be very helpful to Neighbors Against Fibertech. That's concerning. I think that she has a lot of expertise and knowledge on the subject to bring to its discussion, and it's concerning that her vote will be absent. But concerning what DTSD said today about permitting, I think we can all acknowledge that it's a bit disingenuous to say just because of the length of a permit, it's over 100 pages, and then it may be full of procedures and prescriptions that are meant to be followed. We're here because they're not followed. We're here because of decades of noncompliance. And I think the irresponsibility of the permitted agents or the permitted entities needs to be acknowledged. We're not here because the rules are followed. We're here because they're broken. Just looking at the objections of Fibrotech, they don't want community air monitoring. They don't want independent monitoring. And they are opposed to, increasing the data collection on the stormwater runoff, or even, addressing that at all. I would like to meet too, Neighbors Against Fibrotech's requests. And in the future for these hearings, I hope that, I don't know, I wish that Brostrom was up here advocating. We need a fair representation on the board because its creation was to represent our concerns. Thank you.
it's unclear what to do when we get up here, if we should be waiting for a signal. So good afternoon. My name is Angela Johnson Mazzaros. I work at Earth Justice and wanted to offer 2 comments just based on what we heard this morning. So first, when Permitting Division Chief Wayne Lawrenson spoke with you, he noted that the Permitting Division didn't have a position on what the board should do here. But he did note that as it relates to the stay of the permit, that this permit is the longest continued permit in the history of DTSC. So let's just be clear what that means. This permit for PTI expired in 1996, and now it's 2026. And PTI argues that there are conditions in there that are so urgent that they can't wait for the outcome of this proceeding. That's just a disingenuous statement. There were many years when protections could have been put in place and they weren't. And fundamentally at dispute here is whether or not these are protective and whether or not what permitting has provided will meet the requirements of the statute. And that is that if a facility has impacts on the surrounding community that cannot be controlled to an acceptable level, should that permit be denied? So in terms of the stay of the permit, I urge you to accept staff's recommendation and stay the entirety of the permit. Secondly, I want to note that DTSC, while not having a position on the outcome of this decision, did take the opportunity to come here and argue for all the things that it's done right, and to argue for its commitment to protecting the community, and argue for its position that its permit is effective and meets the requirements of the standards. Candidly, that's not an appropriate way to engage with this board related to this question. That is fundamentally an argument about the merits of the permit, and it's fundamentally a way for DTSC to be here trying to impress upon the board its commitment in its permit writing. But this is really just a question about whether or not the permit should be stayed while the proceedings proceed. And if the permitting division doesn't have a position on that, then it should contemplate that decision. Thank you.
Are there any additional comments from in room?
Good afternoon. My name is James Sanchez. I am also with Neighbors Against Fibrotech. Fibrotech has the most Class 1 violations in the entire state of California. Class 1 violations are defined as dangerous to human health and the environment. These violations include, but are not limited to, illegal storage and treatment of hazardous waste and other types of cyanide and acidic waste. Fibrotech was also using unauthorized equipment the DTSC uncovered in violations through inspections conducted between 2011 and 2015. In the year 2000, Fibrotech was fined $5,000 by the EPA and $10,950 by OSHA. In 2003, they also were in violation of workplace safety and were fined $7,560. In 2008, they were in violation of another environmental violation as well by the EPA. They were fined $151,603. In 2010, they were fined again by Southern California AQMD, $19,000. In 2019, they were also fined once again by the DTSC for $495,000. If we consider these numbers, Fibrotech is demonstrating that they are financially able to relocate and find another place to perform their services. We, as Neighbors Against Fibrotech, if the services that are being provided by Fibrotech are necessary, then we acknowledge that. And we are not asking that they be closed permanently, but may they relocate elsewhere. These chemicals that we are here speaking of, they do not operate by words simply asking, please go away or please stop. There is no one here who would allow someone walking down the street to physically harm a member of their family, a child, their father or mother or grandparents. But these chemicals do not operate that way. There's no way you can raise your hand and say to these chemicals, please stop. You may harm our loved ones. We live in this community within less than 500 feet from this building, and they continue to operate over and over. So us, Neighbors Against Fibrotech, we respectfully ask that you would heed with compassion, and we implore you to deny Fibrotech's appeal. Thank you.
Are there any additional in-room commenters? Please raise your hands. I'm taking a poll. Okay, please make your way to the podium.
My name is Greg Fritchell, and I am here partly on behalf of the Clean Air Coalition of North Whittier and Avocado Heights, which is near the location of Fibrotech. We're dealing with a similar fight in our area. I'm also a 5-time candidate for the State Assembly, and one of the biggest issues that I've always been concerned about is environmental protection. But I want people to look at this from the standpoint of the average California resident, if they were looking at this process. When you apply for a permit or a license, you have to meet conditions. And if you don't meet those conditions, typically you get denied and you have to go back and apply again, okay? But that doesn't seem to be the case here, okay? I heard a couple of speakers earlier essentially say that the Department of Toxic Substances Control essentially doesn't have a standard for denial of a permit because they never do. And I think actually, if you look at the actions of DTSC thus far with Fibrotech, and frankly, not just with Fibrotech, but also with other facilities that they are considering granting permits to, I think that their own actions support that argument, because they say that one of the person speaking in behalf of DTSC said themselves that this is the longest stayed permit in the history of DTSC. Well, it stayed because of the choices of the DTSC, because the DTSC didn't have the courage to say, you are not meeting the conditions required in order to us to grant you a permit, so we're denying it. These are the reasons for the denial. You go back and fix these, and then when you do, you can come back and apply for a permit again. They're not doing that, okay? They're also granting permits based on, not on actions taken already, but partly based on actions that they anticipate being taken in the future. Nobody applying for a license or a permit for anything else gets that kind of privilege. Okay, nobody gets to bet on the come, and that's what we're doing here. Okay. The job of the Department of Toxic Substances Control, the DTSC, and by extension the BES, they're answerable to the people of California. And the job of the DTSC specifically is to protect the people of California from exposure to toxic substances. They're not doing it. They need to start. Thank you.
Are there any additional in-room commenters? You may go ahead.
Hi, my name is Ivana Castellanos with Physicians for Social Responsibility, Los Angeles. DTSC has the authority to grant, deny, and revoke permits, and I hear that DTSC wants to uplift its ability to also create permit conditions in the permits that it grants. But permit conditions are not sufficient to address all concerns adequately, particularly if a facility has demonstrated an inability to be a good neighbor, or it threatens the health of the workers or surrounding community. And to many community members and advocates, it can feel like the agency moves through some of its responsibilities like a simple checklist, like, yes, this was done, no, it hasn't been done. And I really invite the board to unflatten that work and to really examine the quality of the work and consider whether, did DTSC do what it could to gather accurate information? Did DTSC do what it could to investigate the community's concerns? Are there any assumptions made in this permit that should be questioned? How flexible should DTSC really be with facilities that have a proven history of documented known violations? Thank you.
Are there any additional in-person comments? Seeing no more in person, for those joining us on Zoom, please raise your virtual hands if you would like to comment for this agenda item, the initial order on appeal for the Fibrotech facility. Seeing only one hand on Zoom, Rebecca Overmeyer Velasquez, I'm going to send you a request to unmute. You may go ahead.
Hi, can you hear me?
Yes.
Oh, hi. Okay, good afternoon. My name is Rebecca Overmeyer Velasquez. I am the coordinator of the Clean Air Coalition of North Whittier and Avocado Heights, and I'm here to give you a short and bitter comment. Thank you. We remember that the Board of Environmental Safety was needed, urgently required when the legislature created it. And it was urgently needed because DTSC permitting staff in particular had demonstrated a failure over the years to do its job to protect the public above all else. And so that was then, and here we are in 2026, facing the very same problem that the public has faced, communities have faced for years. Here we are again, facing the same problem with the permit renewal for Fibrotech. That should never have happened. This facility is the poster child for permit denial. And here we are having to fight the agency, DTSC, again, despite the fact that the BES is in place to help us, to protect the public. So what we have here is another failure by permitting staff that's allowing a polluter, an egregious polluter, to continue operation. I am strongly urging the Board of Environmental Safety to remember its duty, number one duty to the public and our health, and to deny the permit, that is to grant the Neighbors Against Fibrotech appeal, and for sure to stay the entire permit while the appeal process continues. That's the only just thing to do. Thank you very much for your time.
Are there any additional comments from our Zoom participants? Seeing none, Spanish interpreters, please let me know if there are any comments in the Spanish room. Thank you, interpreters. That concludes public comment for agenda item number 3, the initial order on appeal for the Fibrotech facility. Chair Rakestraw.
Thank you very much, Sheena. And thank you to everyone that commented this morning. We really do appreciate the time and effort that you have taken here. So I'd like to now call for a 15-minute break for the board members to have a chance to think through any questions that they might have, to formulate their thoughts as we then move into board discussion of this matter and board consideration of the initial order. So we'll now take a 15-minute break. And then Sheena, will you please tell us what time we will reconvene?
Thank you, Chair Rakestraw. It is now 12:40. We're taking our break at 12:40. We will return in 15 minutes for 12:55. And when we return, we will proceed with the board discussion for agenda item number 3. Welcome back, everyone. It is now 12:55, and we maintain a quorum by having 4 members present. Chair Rakestraw, we are ready to proceed with board discussion for agenda item number 3, the initial order on appeal for the Fibrotech facility.
Thank you very much, Sheena. So we're now, as Sheena mentioned, at the board discussion phase for the initial order, where the board is discussing whether to adopt the initial order draft as presented by the staff or modify it in some way. So I'd like to break apart the discussion in kind of 3 parts, I suppose. The first is we'll have kind of initial set of questions and answers from each of the board members. I would say in the first instance, please direct those questions towards board staff. But if board staff are unable to answer those questions, or you have a specific question for council here, I think that's okay. We would also then give opposing counsel the chance to also respond as well. I think that's only fair. If they want, they can feel free to decline responding as well. So that's basically part 1. That's just kind of getting all the questions answered of the board members. We can then have a bit of a discussion, depending on how that goes, on kind of the more substantive issues contained within the initial order. There are 3 issues, of course, in there. The first is the issues that are being accepted for review. The second is the scope of the stay. And the third is the briefing schedule. Once that is discussed, we'll then turn to a board vote. So with that plan, I'll now open it up to the board. Who has questions that they would like answered? Vice Chair.
Thank you. Thank you to everyone for your participation. I have a question of the department and a question of the facility, but I'll pose it to council and then we can go from there. My question for DTSC is with regard to, not specific to Fibrotech, but in general, upon issuing a permit, when it is appealed, the question of a permit being stayed in its entirety. Some of you know I came from a long time at EPA where upon issuing at the time Clean Water Act permits, if a permit condition was appealed, that condition was stayed, but the remainder of the permit by and large went into effect. And so my question for the department is, as we may entertain future appeals, should we assume that the department's position is that the entirety of the permit is stayed upon upon acceptance of the appeal? So Greg, do you want to redirect that to DTSC, or do you want to opine on DTSC's interpretation of its reg? I just hadn't had the experience before where a permit is almost automatically stayed in its entirety. And so I just need to learn more from this.
So if you have a question about the permit appeals process that preceded the board and how all of that went, I'm happy to talk about that. But it sounds like your question's more prospective and you're really wanting to hear from the department. So we have some representatives of the permitting division in attendance today. I'm not sure who would like to be speaking on that. So I see Wayne coming forward. I think Wayne wants to give your question a thought.
Thank you, Wayne.
Thank you. on the question of, I think we don't have a position on that. I think we look to the board to make that decision. Certainly, we have, I guess, a preferred scenario, but that's just a wish. And that's from our perspective of our permits being protected. But I don't think that we would have a position on what the board should do with respect to the stay. I hope that's somewhat answers.
Thank you. Thank you. And then my second question is for the facility. Normally in the renewal of permits, environmental permits, as a permit is updated, there are various new conditions that reflect either state-of-the-art improvements or best available technology, whatever the case may be. And I'm curious, as the board will make its decision today and then hear the matter in October after being briefed, my question for the facility is, what would be the lead time for installing two of the improvements that council mentioned, namely switching up from the asphalt paving to the secondary containment and switching out the open drum to a self-contained tank? The reason I ask the question is because in any permit, there are going to be ideally state-of-the-art or technological improvements that make it safer for the workers on site and make it safer for the businesses and neighborhoods that abut the facility. And I'm just mindful that if the board will always stay a permit in its entirety, that there may be a lag time later on if the decision is rendered that allows these new improvements to go in place. There's a lag time in putting those improvements in place. And I'm just wondering if you could help me understand for those two improvements that you mentioned specifically, what the lag time would be in installing or procuring and installing those. Thank you.
Good afternoon. My name is Dave Clark. I'm the plant manager for FiberTech. And for those two conditions, there is a 12-month compliance schedule in the permit. So we must complete those two items within 12 months. We estimate it would take approximately 9 months to complete those activities once we start.
Thank you, Mr. Clark.
Thank you.
Chair Rakestraw, I don't have further questions yet.
Thank you very much. Thank you so much, Vice Chair. Which other board members would like to jump in with questions? Member Atkins.
Thank you very much, Chair, and appreciate the question of Ms. Strauss-Hackard. Those are important questions in terms of protection of the public. I have a pretty simple question for our legal counsel, our BES legal counsel, Greg. In terms of the PTI petition, 5 issues for review, I'm curious, and again, I think this is a simple question, but item 4 and 5 on condition 71, the community air monitoring plan, and 5, condition 74, surface water, those are first time in permit issues within the scope. Are those conditions that were added by DTSC as new conditions and they were first time in the permit, so that's why they're being singled out as first time? It's a procedural legal question for you.
So those were singled out because they were listed among the issues that Neighbors Against FiberTech was raising. Am I following
Yes.
that right? That was in their petition. So they're contesting those two parts of the permit. And so that's really, why I think they are new features of the permit. I don't think the facility under its 1991 permit is.
But if I follow it, these issues were not part of the public record and therefore within the scope and previously raised? These are first time raised. This may be, that's why I think this is a
Well-
very simple question.
Maybe Linda's better to answer that question.
Okay,
Sorry.
well, I trust you to know who should.
Yes, that is correct. So they didn't have an opportunity to comment during the draft review of the permit. And so that's why they're accepted for review under the basis of that it first appear in the final permit. So they were added in between the comment period and the issuance of the final permit.
Okay, thank you.
Yeah.
I told you it was simple. Okay, I'll have comments later, but Mr. Chairman, thank you.
Thank you very much, Member Atkins. Member Williams.
Thank you, appreciate it. First, just also recognize the members of the public who came both to this hearing and also those who spoke as well. I appreciate your advocacy and engaging in the spirit in which this board was created for. I wanted to focus on one aspect of the appeal brought by NAPTI, its fourth neighbors, and that's the administrative record. And in particular, because, well, two parts really. It touches on the threshold that an appeal may satisfy to trigger a full permit review. Secondly, in part because the administrative record is really at the core of one of this board's mandates, which is to improve public transparency and increase it. So to begin with questions around satisfying that threshold for appeal, the board's regulations governing the initial order and introduced a broader set of triggers for hearing a full appeal compared to the preceding regime of appeal hearing. And in particular, that expanded set of, or that expanded threshold goes beyond permit conditions to also include both, quote, issues and provisions, so a much broader array and sort of without prejudice to the merits or demerits of expanding that threshold. That is the regulatory standard by which we are asking to consider this initial order today. So to that, neighbors raised that the issue that the administrative record was incomplete and inaccessible at the time the permit was issued. And so to council, is it a statutory or regulatory requirement that the administrative record be complete and accessible at the time that the permit is issued?
Yes, that is an obligation, a requirement that appears in the regulations that apply to DTSC's permitting process. So there is a regulation 66271.17, which lays out the requirements for the administrative record for a final permit decision. And within that regulation, it also speaks to timing and how and when that administrative record is compiled, that as DTSC reviews the permit application, it is compiling the administrative record, assembling it, putting materials into the administrative record, and then when the final permit decision is made, the administrative record at that time is complete.
Thank you. Both board staff in its presentation have described some of the timelines around the administrative record. Neighbors in its appeal detail in more on visiting DTSC's facility, DTSC's office in their challenges around accessibility and a complete record. Is it council's opinion that the administrative record was complete and accessible at the time that the permit was issued?
So when the appeal is filed, the board then sends a request to permitting to request an index. Up to that point, an index per se is not available. That does not mean that the administrative record is inaccessible. It means that individuals who are interested in the permit decision and want to know more need to take it upon themselves to gain more information. And they do that primarily through the web by visiting DTSC's website, which by and large directs them to the EnviroStore database. So permitting has an obligation to keep that current for the sake of transparency. Otherwise, people are really struggling to know what is this permit decision? In this case, there was a lag of time of about 9 months between when the board asked for the index to when the index was provided and the documents that were listed in the index were actually available to review. And I think that was a bit of a surprise for us, and we weren't anticipating that. And so to answer your question, was it available at the time? Well, apparently there was some level of disconnect there because there was clearly a larger universe of documents identified and listed that really hadn't been identified and listed before. So it does raise questions to, what is the intent of that regulation? Was it fully satisfied? I think probably best at this point to just say that we've had our own questions about that, but that's an issue that will be fully briefed and argued and presented at a later stage in the proceedings.
I appreciate that. And again, I think back to the chair's comments that at this stage we're considering whether or not the issues are met as a threshold rather than the substance of whether or not there was, for example, in this case, a procedural defect. I think with that established, I would like to come back further questions about how that may relate to severability and scope of a stay. But I will turn it back to you, Chair. Thank you.
Thanks so much, Member Williams. I will ask a couple of questions myself. I think my first question is actually directed at the Council for Neighbors Against. So I've read and reread the briefings on the issue of the scope of the stay many times. And one thing I keep coming back to is basically, if you look at 66271.71B on the effect of the stay, basically the connection between the first and second sentences. So the first sentence speaking to the effect of the stay imposed shall be limited to the issues that are accepted by the board pursuant to subsection B. And then the second sentence going on to speaking to conditions. Uncontested conditions which are not severable from those conditions contested shall be stayed together with the contested conditions. And so I guess my question for council is kind of both a legal interpretation one, which is basically if you do you have to go to the second sentence if the appellant is challenging the decision in its entirety? Like, do you even have to look at the conditions, or do you just go to the first sentence and say, the issue we are challenging is the decision to grant the permit or deny the permit or whatever it may be, and then we don't then look at the corresponding conditions that go along with that challenge or that issue? And then I guess the kind of like factual question is like, is Neighbors Against in fact challenging all of the conditions, either implicitly or explicitly, that are contained within the permit? So I guess those are kind of like two-part but related question. Thank you.
This question was, do you have to get to the second sentence in regards to uncontested conditions? Our position is that you would not need to get to the uncontested conditions because Neighbors Against Fibertech is specifically challenging permitting's decision to grant the renewal permit. That is the issue that we are raising. And that implicates all of the conditions, and none of the conditions are severable from permitting's unlawful, we would argue, unlawful decision to grant the permit in the first place. You asked a second question, but I forgot the second question.
I think you answered it, which you said that implicates all conditions. So the second question was basically, are you in fact challenging all of the conditions contained within the permit?
I would frame it as the issue we are challenging is permits granting of the renewal permit. And that is specifically allowed for under the board's appeal regulations as it expanded the matters that could be brought on appeal.
Thank you very much. I had a couple questions, I think, for board counsel, but before that, I don't know if the counsel for EcoBat, oh my gosh, PTI here wants to respond to that same question as well.
Thank you. I think you almost gave Matt Williams a heart attack there. So yes, we think that the second sentence is relevant if it's just the issue, if you just challenge the permit decision, it renders the next two sentences irrelevant, and those sentences were put there for a reason. There's the broad issue of challenging the permit, but I think you can dig into that a little bit more and look into what is the particular issue that is being challenged. So when you look at, for example, cumulative impacts, well, what is the issue that, that is driving that? And then I think that there is just a practical question for the board to recognize, which is that what you're going to see in all these appeals is that the issue of the permit decision will be challenged. And so I think the board has a question to decide, an issue to decide for itself. Does it believe that the entire permit should be stayed throughout? That's not what the regulation says. I don't know how much this was contemplated at the time, but you can be sure that that's the practical consequence. And I think the practicality of it should be taken into account.
Thank you very much. I did have one question for our board counsel as well. And I think you had a little bit of, or maybe Linda, you covered this in your slides, which is the DTSC's past procedure with respect to permit appeals, of course, heard by permit appeals officers within DTSC. They were interpreting different regulations, but I understand that you looked into this, and that at least this was presented in your slide, that in nearly all of those cases, the effect of the permit decision, so the stay, applied to the entire permit. So I was wondering if you could just talk a little bit more about that. Like, what regulations were they interpreting? How does that relate to the regulations we're interpreting here? And then kind of the practical effect of that on the decision the board will make today.
Certainly, I'm happy to do that. We did retain some of the records that sort of were handed to us when we took over the permit appeals process. Those gentlemen have since moved on, they've retired, but in anticipation of this, I did look back at some of the past appeals. And first, I want to say that the regulation was different. It did not obviously have a board. It didn't call for the board to make a determination of the stay. And it did not include the word issues. And so the first line that you mentioned, the first sentence, the board shall limit the stay to the issues that are accepted on appeal, didn't exist because it wasn't contemplated at that time that there would be issues raised. Instead, the regulation was only about conditions, and there were situations where appeals were dismissed at the equivalent of this stage in the proceedings because they raised issues, and we didn't hear issues at the time. It's not a completely consistent practice. There were some appeals that moved forward notwithstanding that. And so what I found, and I actually do have a slide, Corin, this would probably be a good time to pull that up. It's the one that I gave you before this. I found 9 instances of appeals where there was an initial order that made a determination on the stay, and then the proceedings continued until an ultimate resolution. One of those 9, it was withdrawn, but the other 8, they all resulted in a final decision. In each one of those, except for 2, there was a full stay. So The one here that's listed, San Joaquin Filter Services, Inc. This was filed by a pro se appellant. That appeal raised issues related to the permit, but also related to corrective action, the cleanup activities that are sort of unrelated to permitting. And the permit appeals officer in the initial order essentially screened that appeal, dismissed a lot of the permitting issues, but retained and heard the issues around corrective action. And because of that, lifted the stay of the permit, because finding at the time, well, the issues that were raised related to the permit are not being heard. We're dismissing those. Courts didn't use the term issues. They would use other terms instead of that, but equivalent idea. So that was one example of that. More recently, in 2019, Chevron appealed its post-closure permit and disputed several conditions in the post-closure permit. There, the permit appeals officer found that the stay could essentially be lifted because there was only two or three conditions that were being contested by the facility. So it's another example of a partial stay. But in every other case, a full stay. And these were the appeals then that moved forward in the process and will ultimately heard, and resulted in a final order. Another and sort of closing observation here, there's only been a few instances of a community organization that filed an appeal with the assistance of counsel. Pretty rare, actually. That didn't happen that often with the permit appeals officer. And I listed two of them here. Lawrence Livermore National Lab, probably the best example of an equivalent situation, was not accompanied at the time by a facility appeal. This is, to my knowledge, is the first time that's ever, well, that's not true. There was one other appeal I found. It's not listed here. It's kind of an old one with limited records, but we actually did see it was SSFL, as a matter of fact, where they had a pro se appellant along with a facility appeal. But by and large, that doesn't happen. So the other example is Ecobat. There was a temporary authorization appeal in 2021, right before the board took over. Full stay, ultimately granted by the permit appeals officer. Same with Lawrence Livermore. That appeal was ultimately granted. In those situations, there was a full stay at this stage in the proceedings. And I guess maybe one more note to make. You'll see here there was a denial of a facility permit. That was GEM in 2020. The permit appeals officer in that case did not take the position that, oh, we can't hear this because you're not disputing conditions, right? So I think what I found anyway is a pattern here that shows that even then there was a sort of a understanding that appeals were not so limited. They didn't apply a very strict limited reading to that and sort of proceeded more broadly in terms of, how that was applied in that practice. Does that answer your question?
Yeah, that's great. Thank you
Thank
so
you.
much. Are there any other questions that any of our board members would like to ask before we get into more of a discussion? Okay, so seeing none, why don't we pivot more to a discussion, I guess, amongst the board. So again, there are basically three issues that are before the board here within this initial order. The first is which issues are accepted for our review. We didn't, from in the presentations, we didn't really hear too much on that from the councils. So that may be a bit of a second tier issue here, at least with respect to what's in the draft initial order. The other issue, of course, is the scope of the stay, which seems to be the kind of primary driving issue in these discussions. And then the third issue, we did hear some comments on this as well, which is the actual briefing schedule for this appeal. So why don't we go ahead, let's just start with the issues that are accepted and which are proposed not to be accepted, or at least partially within the draft initial order here. Are there any comments or anything that board members would like to make about that? Pause for a second.
Chair Rakestraw, I agree with what the staff have put forward based on what I've prepared.
Thank you very much, Vice Chair. Any other comments on this issue? No? Okay. I similarly very much agree with what the staff included in this recommendations. I think it's a thoughtful analysis. I think it's a good model in terms of kind of how to structure the issues, so to speak, going forward. I do want to note, I think it is notable, and this relates to the question of the effect of the stay, which is that kind of by accepting these issues for review, they are characterized kind of quite broadly. And I do think that that is the appropriate interpretation of our regulations. I do think that is the appropriate way going forward in terms of kind of how to characterize the issues. And of course, that's then related to this next question about the effect of the stay is linked to the issues that are accepted. And so I do think that those are, of course, kind of related. So why don't we turn to the effect of the stay? Is there be good to get board members' perspective on kind of what the staff has recommended here in the initial order.
I can envision scenarios in which it would make good sense to, depending on the matters that the board accepts on appeal, for the stay to not be the entirety of the permit. I can think of various reasons why you would want to put in place something that was better. At the same time, I think as a board, we're also going to face where you have an entity that wants a permit denied, which the board does not have the authority to do. The appellant will seek to have a full stay and to challenge the administrative record in its entirety. And so we need to be mindful of the consequences of that way forward. I'm concerned about that, but I also feel that we're at a point in this process where it may be the most expeditious and sensible way forward to hear the matter as we intend in October. I recognize that the parties have not found any common ground with regard to a partial stay versus a full stay, which is not unexpected, but it's unfortunate. And I think that the sooner that we can complete this matter after the year-long tussle over the administrative record, I think that would be in the board's interest. But going forward for future appeals, I am not necessarily as sympathetic to a full stay of a permit depending on the factual circumstances. So in this case, I recognize it's late in the game, that we would ideally have been able to deal with this more than a year ago, but that's not the way it is.
Thanks very much, Vice Chair. Member Atkins, please.
Well, thank you. And to myself and Mr. Williams, who come to this board at a, I think, historic moment where just looking at the questions that both you and the Vice Chair have asked, the comments that you've made, and I certainly thank Greg, you for giving us that history of the permit history. Obviously, it feels like breaking new ground with an administrative record that challenges the complications and two separate appeals from different sides. So I would agree with the comments, again, of Vice Chair Stackler about going forward. I think that's really important to put on the record. And at this point, I would just make just a couple of comments because during the question period, I wasn't intending to do that. You know, I think, I really want to thank the BES staff as someone who, had a full month to review what you have been looking at for quite a long time. And I know how serious that is as the Senate President Pro Tem Emeritus, who participated in SB 158 and understood the significance of that. Member Williams talked about that in his questions. I think today's action, understanding it is limited to the initial order, I really believe that this board and the role of BES, to some of the comments of the public, this public participation and this process is incredibly important. And I feel the weight of that, and I feel that from the staff as well as from the CEO and the chair and vice chair. So I feel comfortable with the direction we're heading based on all of the information that you have provided. And I do want to thank the members of the public, certainly facility representation, Fibrotech, and the other community members, Clean Air, and others who came here to make sure your voices are heard. That is the point to this board. And those are all of my comments, and happy to follow the recommendations of staff with the addition of the timeline that both parties seem to agree with, as long as staff feel like that will work for them. Maybe that is one last question. Does that timeline and the additional of 15 days work for BES staff?
I believe it does. Yeah, we would be supportive, and it sounds like both parties are in agreement with the change to the briefing schedule. So just to repeat that from my notes, it would be 30 days for the reply brief. It would be due September 9th, assuming the other briefs are filed on time. So I think that amendment to the briefing schedule makes sense.
Thank you.
Thank you very much, Member Atkins. Yeah, please.
My concern about extending the briefing schedule, I appreciate that there's seemingly agreement here. It does put pressure on all of us on the receiving end to make sure that there is no delay in getting to our October hearing on this matter. So it just changes where the pressure point is on the preparation of our materials for the board and our review and being ready for that hearing in October. But I'm completely opposed to changing when we hear this matter.
Thank you very much, Vice Chair. Member Williams.
Thank you very much. I'm going to recognize the Vice Chair's comments and concerns in their entirety, and reflect those for the record as well. And I recognize that Council for the permit applicant made similar observations around some of the longer term implications around some of the thresholds that have been set within the regulation for considering issues. Now, in this case, that said, we've, at least I have accepted that the administrative record was incomplete and inaccessible at the time, and therefore satisfied that threshold. Now, that can be remedied in future cases. I don't think it's necessarily precedent setting by the act of simply having a complete and accessible administrative record. Now, that says that doesn't give rise to the potential for sophisticated litigants to be more vexatious in perhaps bringing forward issues of, well, this document wasn't in it and perhaps it should have been, and therefore, again, satisfying the threshold for considering a full hearing on an appeal. So I sort of do want to similarly bookmark that as a concern. That said, here we've accepted that the administrative record, or I've accepted the administrative record was incomplete, not several. And the reason I've focused on this particular one is that it also, in addition to the transparency piece, which is ever so important, the severability aspect of that issue seems to me to strike at the heart of the scope of a stay. How can you separate an incomplete and inaccessible administrative record from any particular aspect of the permit? Because it speaks to transparency and it speaks to the public's ability to see and read and interpret and access and appeal. And if that's not complete, then there is no severability possible in terms of the conditions. Now, as we've discussed, prior version of appeal just looked at the conditions, and that's not the direction this board has taken. And so with that, on that issue alone, and without getting into and notwithstanding the other aspects of the issues raised and recognized by the board, fully support the staff recommendation both on the issues the scope of the stay, and recognize the Vice Chair's comments about the pressure point at which extending the filings will place, which transfers from the appellants in this case to staff and subsequently to the board, and not wanting to result in that delay regardless of whether or not both parties are agreed to it. I think we need to be mindful as well that that creates pressure points for others. So that's it. Thank you.
Thanks very much, Member Williams. For my own part, I similarly support the staff recommendation contained in the initial order, in particular on the scope of the stay. I do think that the regulation text itself is clear, that the effect of the stay shall be limited to the issues that are accepted by the board. And if the board accepts certain issues, then the effect of the stay, of course, will then apply as well. And I do think that looking at the kind of relevant history and relevant other examples, I think that the board, when I was not on the board when we adopted these regulations, but my understanding and my interpretation is that we did intend an expansion of the existing or the preceding permit appeals process, as well as an expansion of the permit appeals process that we used, or that the Environmental Appeals Board for federal EPA used as well, which is what many of our regs are based off of. So this idea of issues here is something that we've had to really grapple with, because it's to some extent something we kind of added ourselves, and it's an issue, of course, that we added here, so to speak. And I think that was a very intentional and purposeful decision by this board to expand the ability of appellants to challenge issues and not just conditions. And so I do think that really does speak to having the effect of the scope of the stay here applied to the entirety of it. I do think, though, picking off of what Member Williams and Vice Chair Strauss-Hacker said, I do think this is very much a fact-specific determination. I don't think that it's really as rote going forward as, if you challenge kind of certain issues, that automatically triggers a full stay. I do think that, and this kind of emphasized to board staff as they're thinking about this issue going forward, I do think that that fact-specific determination, connecting issues, conditions, and the scope of the stay is really critically important. I do also want to emphasize the timing aspect of all of this as well. I do think that it is kind of unfortunate that it's come up in this permit appeal, where already we have had this permit appeal process take far too long, and far longer than the board had ever intended. My goal as chair, and I intend to hold this board to it going forward, is to try to resolve permit appeals within 12 to 14 months after filed. But of course, that's largely dependent as well on DTSC putting forward a complete administrative record and in a timely manner upon request. And so, again, you've heard us emphasize this in previous board meetings, would like to continue to emphasize that request as well. I think that's all I have to say on the scope of the stay issue. Is there anything else on that? We also kind of briefly touched upon the briefing schedule as well. So why don't we, is there anything else to add on the briefing schedule? Executive Swati?
That staff has a counter proposal of, instead of 30 days, 22 days, because we understand that extra time is needed, but it is cutting it very close to our appeal hearing date, and we would want the board to have ample time to review these documents. So the staff is suggesting 22 days instead.
Thanks very much. Swati, is there any board member comments on the counter proposal from staff of 22 days as opposed to 15 or 30? that seems pretty reasonable to me. Vice Chair.
Chair Rakestraw, before we go forward, I just wanted to remind staff that in the draft initial order that we received, that regardless of what action the board may take today, if we could make sure that on line 18 of page 1, we just correct the sentence. There are a couple of words missing. Permittee and NAPT are each an appellant, and it should read, and are collectively referred to as the appellants. There's some words that just dropped out, as happens with typing sometimes. Per our executive officer's comment, I would prefer the 22 days to a longer time frame. I'm just really mindful of what the final weeks leading to a full hearing are like, and I prefer fewer days.
Thank you very much, Vice Chair.
The 22 days puts us at September 1st.
All right, thanks so much. Are there any other board member comments, questions, any other considerations on this issue? I see shaking heads. If not, do we want to take up a motion at this stage? Do we want to take a break? How do board members feel? Yeah, please, Member Williams. I don't know if that was an offer to make a motion, but I'll open it up if a board member wants to make a motion.
I move to adopt the staff recommendation with respect to the initial order and the scope of the stay, in addition to providing an additional or the 22 days for parties to brief, which would set a deadline of September the 1st.
Chair Rakestraw, I second that motion.
Thank you very much for the motion. Thank you very much for the second. Is there any board member discussion of that? Member Atkins, anything to add on that? No. Okay.
Could we check in with our executive officer and her team about whether we're on the, are there any details that we need to clear up before we would vote?
Great. Thank you so much. So why don't I go ahead and I'll restate the motion as I understand it, or I don't know if Sheena, you have it down. I will go ahead and restate the motion. So I understand the motion to be a motion to, oh, I have a request. Just 1 minute.
Take out the word with.
Oh, yeah. Yeah, please.
I think that I'm going to be on a pre-planned vacation right in the middle of that 15-day period, and will be completely inaccessible. So I'm sensitive to your concern, and we have no interest in pushing things back on October, and want to have you all have sufficient time to consider things. And we're happy to work with the parties to work through something. But I think how it's landing right now is particularly difficult.
If we were to, I had misunderstood a comment you made earlier, that you were in support of adding days to the when this would be due. Did I misunderstand you?
No, when we spoke about 30 days instead of 22, I think that creates the space to allow for that.
So you have to do your book report before you go on holiday? Sounds like school, huh?
Yes. I'm not quite sure exactly how it lands, but I may not be able to see the book until I get back. So I'm a little concerned about that.
I'm just checking with staff if you can just give me 1 minute. So then 30 days would be September 9th. It's up for the board consideration.
Thanks very much. Any comments on that? I for one, am sympathetic to it. Of course, longstanding vacation is important. So I think September 9th does allow the board and the board staff sufficient time to review the reply briefs before the October 21st to 22nd hearing. So I'm at least okay modifying the recommendation that's on the table. Is there any other board discussion on the schedule here? Yeah. So for the record, we have amended the motion that's on the table to what's presented on the screen. Why don't we go ahead and formalize the second as well?
Chair Rakestraw, I second the motion that we adopt the staff recommendation with regard to the issues, the scope, and that the briefing schedule reflects what's on screen of being due on September 9th.
Thank you very much. So we have a motion, we have a second. Sheena, will you please go ahead and call a vote?
Thank you, Chair Rakestraw. Member Atkins.
Aye.
Member Brostrom's absent. Chair Rakestraw.
Aye.
Vice Chair Strauss-Hacker.
Aye.
Member Williams.
Aye.
We have 4 ayes. This motion passes with 4 votes as amended. Chair Rakestraw.
Thank you so much. Thank you so much, Sheena. Thank you to our board staff, Greg and Linda. Thank you to council and the public for taking the time to attend today and for your thoughtful public comments. As far as the next steps for this particular appeal, we will be receiving written briefs from the parties in the coming months, consistent with the briefing schedule that is contained in the initial order as subsequently modified. And we will then update our website with any of the briefs that are received. Again, we will then have one public hearing for this matter, which is currently scheduled for October 21st to 22nd. And we are still looking for a venue for that meeting, but we anticipate the location to be in the Los Angeles area. So we'll now go ahead and take a 30-minute break, and we will reconvene at, why don't, Sheena, you're better at timing this out. Tell us when we're going to come back.
Thank you, Chair Rakestraw. We'll take a 30-minute break and reconvene at 2:18. Welcome back, everyone. It is now 2:19, and we maintain a quorum by having 4 members present. Chair Rakestraw, we are ready to proceed with agenda item number 4, the Executive Officer Report. And as a reminder, this meeting is being live streamed and recorded, and your continued participation is acknowledgement that you are being recorded. Chair Rakestraw.
Oh, there we go. Thank you very much, Sheena, and I hope everyone had a good 30-minute break. So we do have one slight change to the agenda. So we have a bit of extra time compared to what we had budgeted for. So we are going to take the Ombuds report, which which was previously scheduled for tomorrow, and we're going to move that up to today. So we're going to ask Lauren here to provide us with her annual Ombuds report following the executive officer report. So the plan is to have the executive officer report, followed by the action items update, and then the Ombuds report all together. And we will then have public comment and then board discussion following that. We will also take the board member reports and instead move those to the beginning of the day tomorrow. At that time, we're going to have board member Brostrom here as well. And so I think it makes most sense to have that item at the beginning of the day tomorrow. We'll also have likely a larger in-person presence, and we'll give our new board members the chance to introduce themselves to the public at the beginning of the meeting tomorrow. So with those administrative issues, we'll go ahead and move into the executive officer report. So Swathi, we'll go ahead and turn it over to you to deliver us with your EO report. Thank you.
Thank you so much, Chair Rakestraw. And for the board members, this EO report, I pretty much cover administrative updates. So updates in terms of hiring for our staff, budget updates, upcoming board meetings. But if there's ever anything that you would like me to include in addition in these EO reports, please let me know. And so today I will cover the board and hiring updates, BES current budget, our 2026 board meeting dates, as well as an update on permit appeals. Next slide, please. So board update, as Chair Rakestraw mentioned earlier today, we do have a new environmental scientist, Ranaji Joshi. Ranaji was born and raised in India and later moved to the United States to pursue graduate studies. He earned his doctoral degree in biocontrol and integrated pest management at North Dakota University, NDSU. He has built a long career in the agriculture industry, specializing in technological development. And most recently, he served as lead scientist with USDA ARS. He brings strong expertise in project, process, and data management, and Ranaji will help support the technical team and the board from the Sacramento headquarters area. We welcome Ranaji. We are so thrilled to have you rounding out our technical team. Thank you, Ranaji. Next slide, please. So our budget update. As you all are familiar, we have a tiny yet mighty team. We have 5 board members supported by 12 staff, and our total budget is $3 million, which includes 2.8 for personnel services and $250K for operating expenses. Through the end of February, we have had a total expenditure of $1.84 million and have a remaining budget of $1.13 million. And I will likely give another budget update in June and thereafter. Next slide, please. Our board meeting schedule for the rest of the year. We will be back in the Los Angeles area on June 24th through the 25th. In July, we will be in Sacramento area. In August, we will likely be in Sacramento, but that's still to be determined. And as mentioned earlier today, October 21st to 22nd is our appeal hearing for FiberTech. So we likely will be back in the Los Angeles area. And we have a tentative November or December board meeting. Next slide, please. Just a reminder about the current appeals that are in front of the board. We have 2 pending appeals for the FiberTech permit renewal. And with EcoBat Resources, we have multiple appeals filing. There's a full docket and additional information at our BES website. We have a drop-down menu where you can find up-to-date information and all of the documents related to both of these appeals. Right. Next, I will pass it to Lauren Chandler, our ombuds, to give an update on action items. So action items are either requests that board members have brought up either during our board meetings or in between board meetings to Lauren to follow up on either with our own BES staff or with DTSC staff. So Lauren gives these updates at every board meeting as to where these action items are. And also Lauren gives an update on public inquiries that Lauren gets at our board meetings. So we end up having many public comments, many public inquiries. And so Lauren gives an update on those public inquiries as well. Lauren, I'll hand it to you now.
Good afternoon. A total of 5 action items were recorded during the public meetings held on February 5th in Sacramento. Next slide. We'll start with the 3 items for DTSC from February, but first I have a correction from November of last year. Next slide. During the November public meeting, Vice Chair Strauss-Hacker asked for the senior management team to report back to the board on their efforts to digitize the administrative record. Deputy Director Mandy Bain responded directly to the Vice Chair in February, reporting that for the 2 final permit decisions that are anticipated this year, DTSC will be able to have the digitized appeal AR prepared in accordance with the timeframes presented in the standing order. This item was incorrectly reported as ongoing during February's presentation, but should have been noted as complete. Next slide. At February's public meeting, Board Chair Rakestraw requested a briefing from DTSC about how the 2020 to 2024 Strategic Plan Outcomes Report will help to shape the current plan's development. The Director's Office noted that the 2020 to 2024 Strategic Plan was created before the current leadership, so the team cannot speak to its development. For the new plan, the department is taking a revised approach by incorporating staff feedback, aligning with the director's annual priorities to avoid duplication, and actively refining its mission, vision, values, and goals with staff input. While the plan's development is ongoing, this action item request for information has been logged as complete. Next slide. Chair Rakestraw also requested a follow-up briefing or regular updates on the Governance Subcommittee for Director's Priority 3.5 regarding artificial intelligence. The Director's Office responded that the department is currently exploring AI implementation with programs evaluating tools like Microsoft Copilot and Poppy to identify how they can support existing workflows. While the AI policy enables use, programs are working with the Office of Environmental Information Management to develop specific, ethical, and safe use cases for this technology. This request for information has been logged as complete. Next slide. Former Member Gomez requested a dedicated presentation from DTSC at a future public meeting about orphan sites. The Director's Office and BES are currently in discussion about the best options for presenting this information to the board, including an SMRP 101 presentation that could lead to follow-up conversations on orphan sites, or it could be put together with SMRP metrics work. This item is in progress and will be revisited. Next slide. Moving on to the action items for BES from February. Next slide. Former board member Gomez asked for an update on Chiquita Canyon from Cali, PA. Chair Rakestraw and Vice Chair Strauss-Hacker will be meeting with Cali, PA Deputy Secretary Lichtig to discuss, so this item is still in progress and will be revisited. Next slide. Former member Gomez also requested that the comments received from the public about BES's evaluation of DTSC be appended to the final published version of the evaluation. At the February 5th public meeting, the board approved the evaluation and opened a 30-day period to receive written comments from the public. Once the public comment period closed on March 9th, the comments received during the February 5th meeting were transcribed and added to the remainder of the comments that were received in writing during the 30-day period. All comments were published with the evaluation on BES's website, and this item is logged as complete. Next slide. While we would normally introduce public inquiries received during our last public meeting here, there were no follow-ups received in February. Next slide. For information about the board, the Ombuds program, or upcoming BES meetings, please visit our website at www.bes.dtsc.ca.gov. Thank you for your attention. Now on to the Ombuds report. Once again, my name is Lauren Chandler, and I'm the Ombuds for the Board of Environmental Safety. And today I'd like to give you an overview of the Ombuds program and its work during 2025, with a look at some of the trends I've seen and a view towards 2026 and 27. First, however, as Ombuds, I wanted to ensure that my content and materials are accessible and available in both English and Spanish. At this time, I'd like to ask everyone to locate the two tabs at the very top of your Zoom window. You'll be able to select either the English slides or the Spanish slides. Please make your selection now to follow along in your preferred language. Now on with the show. Next slide. This presentation will touch on what the Ombuds program is, what it's not, and how it can help the public, how inquiries are received and processed, a quick look at trends and recommendations, and finally, our contact information so that you can reach out directly and discover how the program can assist you. Next slide. So what is the Ombuds program? Put simply, an Ombuds is a friend who understands the system. My role is to act as an impartial go-between to the board, the department, and the public. My primary responsibility is to ensure transparency, accountability, and fairness in keeping with the SB 158 mandate. I'm here to assist individuals and groups that feel that they may have been treated unfairly or that their concerns have not been properly addressed when brought up to the department. I'm also here to provide access to information and resources, to answer questions, and to help navigate the often confusing complexity that state government can be for the people most impacted by the environmental work being done in their neighborhoods. And most of all, the Ombuds program is here to ensure that every inquiry is handled with dignity and clarity to completion. Next slide. There are, however, some limits to my role. First and foremost, the Office of the Ombuds has no authority over the board or DTSC. I'm able to recommend solutions, but I can't force action. My role is strictly advisory. The Ombuds also does not conduct formal investigations. The Ombuds is not a part of the court or law enforcement. I cannot impose penalties, overturn decisions, or award damages. While I do research the inquiries I receive, I don't conduct any official investigations that adhere to legal standards of evidence required for court cases. In keeping with this, the Ombuds is not an attorney. I cannot offer any legal advice, but I can explain processes or rights in general terms. This means that the Ombuds overall is best for bringing unfair treatment or maladministration to light, for explanations of events or delays within the department, and for pushing process improvements. Next slide. So what exactly is an inquiry? As it relates to the Ombuds program, an inquiry is a request for information, guidance, or assistance regarding an issue with a public authority, organization, or institution. In our case, the Department of Toxic Substances Control. Inquiries help us to determine whether further action on our part is necessary or whether the issue should be addressed through other channels. We can also help the public to clarify what their rights are and what options they may have for action. So what happens to the inquiries that we receive? Next slide. Each day, the Ombuds email and voicemail are checked for new and follow-up inquiries. Each request for information is logged internally for tracking purposes, and appropriate responses are researched. Have we had similar complaints or issues? Does DTSC even have oversight? Inquiries are then responded to directly or referred either within BES or to the appropriate DTSC program for resolution. These resolved items are later grouped together and reviewed for possible discussion or presentation to the board or DTSC. With that in mind, let's get into the breakdown of the inquiries received in 2025. Next slide. I started with the board in June of 2024. My very first Ombuds presentation was in December that same year. In those 6 short months, I'd received a total of 48 inquiries from the public. Using that number to estimate the likely number of inquiries that we would have received over the course of 2024 shows us that 2025 brought a slight decrease in the total number of inquiries received. The majority of the 2025 concerns and questions related to policies and procedures that can affect residents, businesses, and community groups statewide, with Northern California related queries close behind, followed by Southern California and the Central Valley. These queries were mostly received electronically via direct email to a specific BES staff member, an email to the Ombuds address, or to the BES info mailbox, followed by comments and questions received at public meetings, and a few that have actually picked up the phone and called me directly. For my 2026 report, I'll also finally be able to say that our Ombuds form on the BES website was utilized, but not at all in 2025. My immediate interpretation of these numbers is positive. We've made progress in terms of outreach, communication, and problem solving. But how can we do more, not only for the public, but with our DTSC programs? Next slide. With 48 total inquiries and referrals this year, or 59% of total submissions, the Hazardous Waste Management Program has been an invaluable and highly utilized resource for information about fees, permitting, the hazardous waste tracking system, and of course, DTSC's hazardous waste management plan. Site mitigation and restoration inquiry referrals are generally concerning land use and the California Environmental Quality Act, or CEQA. Our catch-all category, miscellaneous, includes questions about everything from who handles accident cleanup on the freeways to mass email campaigns from sites like baykeeper.org and actionnetwork.org that have asked DTSC and the board to do more to clean up California. Safer Consumer Products, the Office of Environmental Equity, and the Environmental Chemistry Lab round out the programs that inquiries were referred to. I'm excited to note that the majority of these inquiries were able to reach a resolution within a week, and that is largely due to the receptivity of program leadership and staff. The people I've reached out to for resolutions have been courteous, efficient, and thorough in their responses, and it's a pleasure to work with them. I hope I can continue to build on those relationships going forward. Next slide. How have inquiries changed since my last presentation? Well, as you can see on this slide, I was able to get a bit more granular with departmental referrals, shrinking the miscellaneous catch-all by about 6%. Overall, the statistics largely remain the same, with a noticeable increase in Safer Consumer Product Program referrals as curiosity and concerns about PFAS move further into focus. The Hazardous Waste Management Program remains champion, with more than half of total inquiries pertaining to or referred to them. What makes HWMP such a giant component of our graph? Let's break it down a little further. Next slide. As you're all aware, the Hazardous Waste Management Plan was a huge part of both DTSC and BES's work in 2025 as we moved toward an approval from the board. So a whopping 65% of my inquiries last year were related to that. From there, questions from the public were almost evenly divided between violation scoring procedures, permitting, fees, supplemental environmental projects, and the Regulatory Assistance Office. Our favorite miscellaneous category acts as a catch-all here for general questions either about the program itself or related to hazardous waste overall. All 2025 inquiries for HWMP were responded to timely and completely, and there are no cases outstanding. As previously noted, and what I can't emphasize enough, is that this is due almost entirely to the responsiveness of staff. Next slide. Part of building these cohesive working relationships begins with our subcommittee for the Office of the Ombuds. With the help of Board Chair Rakestraw, Board Counsel Greg Forrest, and our Executive Officer Swati Sharma, the Ombuds Subcommittee works to support the effectiveness, transparency, and integrity of the Ombuds Office and its processes by reviewing the inquiries we receive, monitoring the progress of those inquiries, advising on best practices, and following up on outcomes. In essence, the subcommittee is there for me, providing focused assistance and ensuring that I have the resources, guidance, and oversight necessary to perform my role effectively. I look forward to more strategic input from them as the direction of the Ombuds program continues to evolve to meet the needs of the public and shape our long-term goals. In keeping with those goals, there are a few recommendations I'd like to put forth to better serve our stakeholders based on the inquiries that I receive most often. Next slide. One of the most impactful things we can do is to make DTSC and BES easy to reach, and when people do reach out, make sure that they feel heard. The most common reason people contact me as ombuds is straightforward. They can't get through to an actual person. Though our website has solid information without designated public contacts, constituents tend to get lost and we lose the ability to track responsiveness. Establishing specific, visible contacts within program staff would help streamline communication and reinforce public trust. In keeping with the idea of transparency and accountability, establishing standards for response times can help to set clear expectations to the public and gives the board measurable benchmarks to track. Response time standards don't just improve service, they make delays visible, which is essential for oversight and continuous improvement. It is a fact of life that urgent matters can take precedent over daily operations. People get ill, people go on vacation, people retire. Delays may be inevitable, but silence shouldn't be. Proactive updates that acknowledge setbacks or wait times, explain the cause when appropriate, and offer revised response timelines can create a reliable pathway for communication and, again, help maintain public trust. Next slide. In line with recommendations in measuring success, what do my intentions for this program through 2026 and into 2027 look like? One of my primary goals is to deepen BES's engagement with the public in tandem with the Environmental Justice Advisory Council. By fostering regular and meaningful interaction, we can ensure that the voices of impacted communities are heard and reflected in our work. I will also be introducing metrics to track my own progress in addressing public concerns, evaluating the impact of our outreach efforts, and improving responsiveness overall. These metrics will serve as both a benchmark for success and a tool for continuous improvement. Finally, I'll be seeking out more targeted professional development and training opportunities, particularly in areas like conflict resolution, environmental justice, and best practices for ombuds. I'm also hopeful that I'll be able to develop my language skills, because I was going to say this in Spanish, but I'm going to mangle it terribly. Because although I can understand much, I don't speak it very well. And to me, that is a personal failing on my part. So I'm hoping to expand those capabilities. That being said, next slide. There are currently many ways for everyone to reach out, not just through the website intake form, but by email, by phone, and at these public meetings. And for those of you that are here in person, next slide. We even have our trifold pamphlet containing all of the contact information that was shown here today, as well as information about who we are and what we do. I look forward to hearing more from everyone in the future. Thank you.
Thank you very much, Lauren. And thank you very much, Executive Officer. So we'll now go ahead and open up this item for any public comments before we then turn to board discussion on this matter. So Sheena, will you please take us through public comments?
Thank you, Chair Rakestraw. We will now open the floor for public comments regarding agenda item number 4, the Executive Officer Report, and the 2025 Ombuds Report. I will start with in-person participants. Is there anyone in the room that would like to comment? Please make your way to the podium.
Hi. I just want to connect some dots. So from the executive officer's report, we saw the list of potential scheduled meetings. And what we're seeing is that some of us are trying either virtually or in person to show up, get engaged, educate ourselves the best way we can, advocate both with the board and our contacts at DTSC. And this is going to probably sound strange, but I don't remember Director Meredith Williams never being absent. I remember her always being here, and I did not have a good, healthy relationship with her. We were always at odds, but she was always here. She heard the critiques. She knew what the arguments and accusations were that came against her agency. And I wish that Director Butler would show up. If I can drive across town, I've got a kid at home, I've got plenty of obligations. I wish that that was a part of this process, that the lead of the agency would show up to these meetings, because then I think there might be a better chance of what she hears here from the community. This is our probably most frequent opportunity to bring our issues to light. There would be more opportunities for our issues to inform her priorities. There's a definite disconnect between her priorities, her evaluation that she decides what to be evaluated on. Our comments are then, stapled to the end of that, and we don't know how our comments are going to inform next year's evaluation or if they will at all. And it's very unlikely that they will if she's never here or rarely here or doesn't listen to our comments. In terms of the ombuds report, you seem so lovely, and I'm sorry that my tone is always so stern. It's because I get nervous public speaking. You laugh, I get overly stern. In my advocacy for SSFL remediation, we've had some really big documents released. Our general soil cleanup for 80% of our site was slated to start this summer. It is now slated to start in December, but the only way I found that out was digging through the DTSC website. It took way too long because the person assigned to do community outreach or public relations for us had left the department. So our emails were going unanswered. So Katie's not here. Our emails aren't being returned. We're waiting for some very big documents to be released, like how they're going to do what they've already agreed to do. We don't have a scientific advisor who's going to analyze those documents. We don't get 45 days. We're coming with homegrown expertise, and we can't even get an answer of when the documents are going to be released. When we saw Director Butler at a environmental justice symposium, that's what we're cornering her and saying, did you know about this A, B, and C? She's saying no. There is a definite issue with our issues not reaching the agency, emails not being returned, not being able to find information, all while people were saying, hey, there's increased transparency. I also think the metrics of what is being emailed to you, there needs to be a qualitative explanation, because we all know that 60% of those hazardous waste permit issues were probably communities across the state saying, please don't pass this. And you did. But no one would know that there was this high conflict, high drama across the state in relating to the board if you just looked at the ombuds slides. And I think for all of us to grow and learn how to navigate this, it would be really great if when we look at the slides, especially for the new board members, they could see what those engagements kind of consisted of. And I'm sorry, I didn't realize I'd run out of time. Thanks.
Thank you for your comment. Are there any additional in-person comments?
Chair Rakestraw, if I may.
Yep, please go ahead, Vice Chair.
We don't usually respond during public comment on an item like this, but you've made the effort to be here all day today and at so many of our meetings over the last 4 years. So in recognition of your advocacy, I just wanted to point out that as we structured the agenda for today and for tomorrow, we needed to address the appeal today, and it made the most sense to give Director Butler a predictable start time tomorrow for her leadership report. And she made the commitment to be here in person tomorrow. I'm not suggesting, Jenny, that you spend 2 days on the freeway, given your commute, but I did want to represent that you might want to comment either here or from home on Zoom tomorrow. Okay.
Thank you. And just to add, I believe she is also listening in virtually. So she has heard your comment, I believe.
Thank you, Chair Rakestraw. Zoom participants, if there are any folks on Zoom that would like to comment on this agenda item, the Executive Officer Report and the 2025 Ombuds Report, please raise your virtual hands. Seeing no hands raised, thank you, Mark. And there are no comments in the Spanish room. Chair Rakestraw, that concludes the public comment period for this agenda item.
Thanks very much, Gina. So we'll now open it up for board discussion. Any board questions, comments that they'd like to make, either on the Executive Officer Report or the Ombuds Report. Who wants to kick us off? Member Atkins.
Well, thank you, and thank you for both reports. I wanted to just comment on the Bud's report, and it's very nice to meet you, Lauren. I appreciate it, and I would like to spend more time on this going forward. I was frankly surprised at the small number of contacts that you receive, and I think you spoke to that in terms of how to do more education to make sure that you are seen as a resource. I am new to the board, so I have to give it time to kind of see how processes work and how programs work. But I come off of having been an elected official for 30 years, and constituent services was always in my mind the most important issue. And the number of calls that I have gotten over the years related to issues that would fall in this arena. And as someone who had to learn, particularly when I got to the state, how to access resources and get responses to community members on an array of issues. And, I really, Chairman and colleagues, I look forward to working on this because I think there are a lot of things we can do, not only to make Lauren more busy, but to actually work in conjunction with you, because as members of a public board whose mission and commitment is transparency and making sure accountability and public access, but also education around the changing role of DTSC and how to make that link and that nexus. I very much, I know that I'm going to have an opportunity to talk tomorrow and say how much I appreciate what the board chair and executive officer have offered me the opportunity to do while I'm on this board. But I really think this is one of the most important things. So I look forward to doing this work with you and finding ways for people to access you. And because I think education has got to be a big part of how we change the culture of what people think, and we are the ones that will help be the bridge for DTSC. And so I appreciate the report, and I look forward to working on this to make sure that we are really responding. I'm glad that you answer a phone. The biggest complaint I ever have received is people who don't get to talk to someone in person, and particularly vulnerable, disadvantaged communities with language needs and access. So we've got our work cut out for us, but this is an incredible role given the youth of this board, I would say, in terms of your longevity. So those are just comments. Thank you, Mr. Chairman.
Thank you very much. Either of you?
If I may, thank you.
Yeah, please go ahead, Member Williams.
I wholly agree with Senator Member Atkins's comments there and the work going forward and the importance of that. And I just wanted to build on that, if I may. I think one of the recommendations was that we designate specific points of contact within DTSC to support more efficient communications. I wonder, as we look at that, whether there's consideration of can that be done without removing the ombudsperson from the cycle or from the loop of communication between the public and the department? And I'm not sure whether it's a technological solution or not, but I would, and valuing how much your office and your work brings to this, would hate to see that the board is not as ingrained in that back and forth between the community and the department, both in terms of the issues being raised, the timeliness of responses, and to Jenny's point, the quality. I think it's qualitative, and that's another piece, but a quality of the response. I think important that the ombuds person is ingrained in that. And then just to Jenny's point on the qualitative data that's coming out, I think that's an interesting piece in where the public is interested in the kind of issues engaged. Certainly as a new member, what constitutes this within the hazardous waste conversation, for example? Is it a particular issue? Are there recurring themes within those categories of issues? I'd welcome insight to the extent that that's doable without creating 5 new positions to support that work.
Thank you very much, Member Williams. I just would echo, I strongly agree about the importance of the kind of the quality of the responses as well. So, and I guess the responses, both, from the board to the member of the public, but also of DTSC to what we are asking. And, I fully trust, and have been involved in this, but I do think that that is kind of a critical role to growing the influence and growing the importance of the ombud's position, is making sure that kind of we are seen as sufficiently responsive to what the public is asking. So I think that's, I really want to echo that point. I did really like your recommendations, Lauren, that you included in there, designating specific points of contact for DTSC divisions, setting standards for response times, and then improving communications with regards to delays. Of course, these are each issues that come before the board that we hear from the public quite often. So I would really encourage you to find a way, and I'm happy to assist with this, to get DTSC to incorporate these recommendations, because I think they're quite important. And I think just the last thing that I'll add is I did also like your idea of working with ombuds at other agencies to see what sorts of issues that they're similarly coming across. And, there might be, as Member Atkins mentioned, a lot of parallels with the legislature as well. So kind of expanding that outreach to figure out how to best fulfill your role. Are there any other comments or questions that the board has on this item? If not, we will go ahead and close this agenda item and move to the closing remarks. So I don't really have a lot prepared for closing remarks. We have another half of our board meeting tomorrow. Again, that concludes day one of our April board meeting. I would like to take the time to thank our board members and board and support staff and board staff for their assistance today. So tomorrow we will have our day two of our board meeting starting at 9 a.m. Tomorrow's agenda includes board member reports, an update from DTSC Director Butler. The board will also consider an update to DTSC's hazardous waste facilities operating permit decision status report for the Clean Harbors Buttonwillow facility, and we'll then have an update on the Exide facility cleanup from DTSC, and close out the day by reviewing our action items and considering for approval the meeting minutes from our February meeting. We will also hear public forum for items not on the agenda around 1 p.m. tomorrow. So we look forward to seeing everyone tomorrow. And Sheena, over to you to close us out.
Thank you, Chair Rickshaw. Today's meeting is officially closed at 2:58 p.m.